Good morning and welcome to the Court of Appeals. I'm Judge Michelle Rick and I'm delighted to welcome you here. I'm equally delighted to be sitting today with Judge Maldonado and Judge O'Brien. I wanted to give just a couple reminders as we get started. First off, to the extent that there are victims in any matter, we ask that you use initials rather than full name. We are not simulcasting, however, our hearings are posted after the fact to YouTube, and so for privacy concerns, we ask that you respect that. There are a couple of adjustments that I would like to propose to our docket this morning. We are taking case number 5 out of order, and I'll be calling that momentarily as all of the parties are remoting in. And so, I see them on the screen now. Welcome, counsel. And we also have the media is here for matter number 4. Are the attorneys present for matter number 4, Ms. Rauchi and Ms. Sharon? Okay. Would it be acceptable to the two of you if we move that to the second item on the docket? And then we'll be able to, we may take a break and be able to let the media folks disassemble. Perfect. Thank you. All right. Anything else that either of my colleagues feels I need to announce? Hearing nothing, then we will call the first matter, and that's item number 5 on the docket, case number 369-204, People versus Justin Allen Lamart. And Ms. Walsh, I believe this is your opportunity as appellant, so take it away.
Good morning, Your Honor. Susan Walsh on behalf of Justin Lamart. I would like to just start out by letting you know that Mr. Lamart's mother is there in the courtroom. I'm sorry I wasn't able to meet her, but she is there to support her son. I know that the court is very familiar with the briefs, and I believe that this matter has been very well briefed. I would just like to touch on the Prude matter, which was decided after I filed this brief, excuse me. I believe it's very strong support for dismissal and vacation of the convictions in this matter. In the Prude matter, the defendant was told that he was being detained and he drove away. The court found that there was no reasonable suspicion to keep him there, and therefore that the police officers acted unlawfully. And the same is true here. There was a call that Mr. Lamart was trying to flag down a car, but there's nothing illegal about that. And then when the police approached him, there was nothing that was, no criminality going on. And instead of just seeing that, everything's fine, we've done our welfare check and letting him go his way, the police officers extended in an attempt to do an investigation on Mr. Lamart, who I believe they knew of him. And so that was unlawful. That he should have been allowed to just walk away if he so chose. And so I believe that that's a very strong issue for vacation of his convictions. The other issue that really is bothersome for me is these videos. And I did also supplement my brief with the other case out of Montcalm County, where lo and behold, again, the videos weren't working. I think it puts the defendants in a kind of catch. Well, it puts them in a, they have no teeth to their argument because nothing was destroyed. And it's not that the police, it's something that's not there, but it's not there because of the negligence or bad faith of the police officers. Now we have this technology.
Ms. Walsh, what evidence do you have that there was bad faith? That's a pretty strong allegation to make.
Well, I think that or I think it was the first officer who testified, and I apologize, I can't remember his name. He said that he knew what he was supposed to do, and he knew he was supposed to turn in and make a written report, and he didn't do those things. And I think that coupled with the Moore case, shows that they aren't using good faith to follow the policy of the county, which is that these interactions with civilians are going to be videotaped, and they're not being videotaped. And so I think, it's difficult to make that argument within the parameters of the case law that's out there regarding like destruction of evidence or not turning over evidence. But I think that it is similar to those situations. And at the very least, a jury instruction should be given to the jury.
I'm still not convinced that equates to bad faith. I mean, was there other information elicited during testimony? I mean, bad faith suggests, scienter and a definitive determination to do or not do. And that wasn't my impression when reading the transcript. I mean,
well, I think that, the word bad has, a negative connotation, but if I'm not doing all the things that I'm supposed to do, I have policies and directives from my employer, and I'm just not doing them. That's certainly not a good faith effort. And so the opposite is bad faith. I'm behaving in bad faith. I'm not doing what I'm supposed to do. And these officers knew what the policy was. They didn't have their machines working properly, and then they didn't even write out the proper reports when they were done. So I do think it shows bad faith on their part to follow the policy of their county, which is to ensure now, and this isn't a busy county. This isn't that difficult. Just get your machines working and then go out with your day. I don't see how it's difficult at all. And I think that's another argument in support of it being bad faith, is that this is not rocket science. This is something that can easily be done, and it wasn't done. And not only in this case, but in the Moore case also. And also, the Mr. Lamart has asked for remand, and so we can do an evidentiary hearing and maybe get an investigator and get some information about how well these officers are following that policy.
Thank you. Does the panel have any questions? No. Okay. You have plenty of time for rebuttal unless there's anything else you'd like to add at this time.
No, I think everything else is adequately set forth in the brief that I filed.
Thank you. Then we'll next hear from Ms. Wilson, Attorney Wilson.
Yes. Good morning, Your Honors. Monica Wilson, Assistant Attorney General on behalf of the people. I agree the initial issues were briefed. I would just like to touch on the two issues from the supplemental. As it relates to the body cam footage or lack thereof, I don't think it's a Brady or a Youngblood violation simply because the evidence never existed in the first place. And I believe it's Youngblood that talks about it. The remedy is that trial counsel is free to argue to the jury about the lack of video footage. And that's exactly what happened in this case. So I think that's the remedy for the lack of footage. And I agree, Judge Rick, with your questions that there is nothing here that indicates a bad faith actions on behalf of the officers. I believe he testified that he thought he turned it on, but it didn't start recording, and there was nothing to the contrary presented. So I think that question was before the jury in terms of the cross-examination of the officers and in terms of the closing argument. So I think that that is the proper way to present that argument to the jury, which is through counsel's arguments and questioning. And I believe that the implication from the jury's verdict is that they didn't take any bad faith from it. As it relates to the other issue, I don't think Prude is applicable here. I think the Jenkins case that I cited is more on point. This is an unusual situation in that it started out under the community caretaking exception to the officer's conduct. It morphed then into a consensual encounter where they asked Mr. Lamar for his ID. While they were running the check, he tried to walk away. And granted, I think the trial court properly recognized he could have walked away if he wanted to. But I think what separates this case from Prude is that Prude was arrested when he tried to leave. And in this case, Mr. Lamarty was not arrested until after the lien came back with the warrant. So there was a legal basis under which to arrest him. He was not charged for any of his conduct prior to the warrant being revealed to the officers. Where in Prude, I believe it was presence in a high crime area, and that's what their basis for the stop was. In this case, again, it evolved on the street, but again, all of the conduct he was charged for occurred after the police's knowledge of the warrant. So I think Jenkins, as I cited in my brief, is more factually similar here than the Prude case.
Thank you. Any questions?
No, I have a question.
Yes.
It's concerning to me that during the trial, a question was asked about the defendant's prior conviction.
Correct.
Basically the same crime he was on trial for. And there was no cautionary instruction given after that. How do you address that?
And I think that is one where I don't believe trial counsel ever requested a cautionary instruction. So I don't believe they raised, and I apologize, I can't remember if they raised the issue of ineffective, but I think it was a brief comment because they were explaining how they knew Lamarty. And I know that they did not get into very specific. So I believe it was just a very limited question as to how they knew the defendant, in which was part of the reason for their stop and their belief that he potentially had a weapon on him. So I think had a curative instruction, or not a curative, but a limiting instruction had been requested, it could have been given, but I don't believe one was ever asked for.
Thank you.
Well, to follow up on that, counsel, it seems that perhaps the prosecutor hadn't properly prepared witnesses. I mean, this clearly was an area inappropriate to delve into during the case for obvious reasons. And, that's something that, we've seen in other cases. I experienced as a trial court judge myself. I mean, there is an obligation of the prosecutor to properly go over, what's permissible and what's not permissible without putting words in the mouth of the witnesses. So could we maybe focus a little more on that and whether that is, whether it's a structural error? When you delve into areas obvious to everyone, shouldn't be delved into.
And there wasn't a limiting instruction, correct?
No.
Yeah.
And so, Your Honor, I guess how I would respond to that is, I guess I would look at it from the lens of prosecutorial misconduct, which I think is how it would be framed. And when you look at prosecutorial misconduct, the question is, was it objected to? Was the limiting instruction given? And I think the case law is pretty clear that, let's assume it was an improper question, that a limiting instruction wasn't given. It wasn't objected to, or I believe at one point it was objected to, but no limiting instruction was given, meaning that I believe had a limiting instruction been given, then I think that would have addressed the issue, but I think it ultimately what it comes down to is that it's not outcome determinative, because I believe you have the question here, and Mr. Lamarty himself testified. I believe the question just became, you can look at his conduct when they tried to arrest him. So I don't think there is any outcome determinative error here.
Okay, any additional questions for
No,
council?
thank you.
No, thank you. I think we understand your position. Thank you, Attorney Walsh.
Thank you, Judge.
Attorney Walsh, any rebuttal?
Yes, it's my recollection that the defense counsel did object to that line of questioning, and that objection was overruled. And so I think that is preserved, and I think that it was structural error and that manifest injustice by bringing up that prior conviction. And then I would also note that in the Prude case, there was a no trespassing rule at the parking lot where the defendant in that case was parked. So it wasn't, just, he was doing nothing. He was parked in a no trespassing area. And so I think that it is, very analogous to the present case, and compels a reversal of the court's decision.
All right, thank you very much. We have this matter, I think we fully understand your positions, and we will submit it for review and determination. So thank you, counsel.
Thank you,
Thank
judges.
you.
Have a great
Thank
day.
you.
So as we mentioned at the start of these proceedings, we're going to adjust the docket and next hear number 4 out of order, which is docket number 366-966, People versus Jason Simmons.
Is there a way to lower this podium? Like the.
The Supreme,
No? Okay. I feel like maybe I'm shorter than the last time I was here.
you can bend the microphone down if
No,
that would
that's
help.
okay.
Okay, yes, we are not the Supreme Court.
Yeah, I'll just stand on my tippy toes then. Maybe I was wearing higher heels. Okay, may I begin?
Yes, you may.
Thank you. Good morning, Your Honors, and may it please this honorable court. Alona Sharon on behalf of the defendant appellant Jason Simons. Your Honors, for the most part, I'm going to rely on my brief for arguments 2 and 3, and really would like to tailor my comments today to the court regarding portions of argument 1, which addresses the trial court's assessment of various Miller factors. And I am going to mostly heavily focus on whether or not Mr. Simons is rehabilitated and or capable of rehabilitation, and the trial court's error in assessing that critical Miller factor. And I want to start out first by addressing the prosecution's brief. If you look at the prosecution's brief, right, we have about 30 pages of statement of facts, followed by about 5 to 6 pages of a cut and paste of the judge's ruling from the trial court at the conclusion of the Miller hearing. And that all culminates in the assertion by the prosecution that the trial court clearly considered all of the evidence before it determined that the prosecution rebutted the presumption and reimposed LWOP. And that's at page 41 of the prosecution's brief. But what the prosecution fails to do in its brief is address any of the case law that's been cited by Mr. Simons, including the Granger case, the Wheeler case, and the Bennett case. Bennett, of course, is published. Wheeler and Granger are unpublished. But of course, even though it's unpublished and not binding, I believe that Wheeler and Granger are very much persuasive for this court due to the similarity between those respective defendants and Mr. Simons, their MDOC records, and the analysis in which this court engaged in both of those cases. And so I want to just take a moment before I highlight some of the facts from those cases that I don't dispute for 1 second that this is a horrible case, right? It is one it's hard to talk about. It is It's not only a murder, but it's also a sexual assault on a very young child. And I don't want the court for 1 second to think that I make light of the facts or the violence in this case, and neither does Mr. Simons. Having said that, this court has repeatedly recognized, and I believe very explicitly in Bennett, but repeated in other cases, that although there is a heinous crime that was committed here, that alone is not enough to determine that Mr. Simons is irreparably corrupt. And if he is not irreparably corrupt, then a sentence of life without the possibility of parole is disproportionate, it is unconstitutional, it is in violation of Miller, Montgomery, and a litany of cases that come after those two cases. And so I want to take a moment really to address Granger and Wheeler, and to the extent that those cases cite from Bennett, because I believe Bennett comes before both of those cases. Granger is out of this court from August of 2022. Granger killed a woman who was out jogging, and it appears from the record that he at some point intended to sexually assault her, but then changed his mind. This court instructed the trial court that it had to look to the 35 years of evidence that it had before it, because that was the length of his incarceration prior to his Miller hearing, to determine if he was irreparably corrupt. And the fact that Granger committed a crime that the evidence suggested was premeditated did not preclude him from getting a term of year sentence. And the Granger court, again, as I just said, cited Bennett for the proposition that all of these cases are horrendous. They are all painful, but that again does not preclude an imposition of a term of year sentence. The question, as Granger says and cites from Bennett, is not whether the defendant is fully rehabilitated at the time of the Miller hearing. The question before the trial court is this defendant capable of rehabilitation? Because if he is capable of rehabilitation, then he is not irreparably corrupt and not deserving of an LWOP sentence. And I argue in the brief that that is one of the top and most egregious errors that the trial court makes, is that she makes a finding that, well, Mr. Simons, I can't say that Mr. Simons is rehabilitated today, so I'm going to impose a sentence of LWOP. And the prosecution even acknowledges that at page 47 of its brief, because the prosecution's brief acknowledges that the trial court's concern was not that Jason could not be rehabilitated, but that, quote, he has not yet been rehabilitated. This is not the legal standard. It is a mistake of law by the trial court, which by definition is an abuse of discretion. I, of course, would argue to this court, as I do in the brief, that Mr. Simons is absolutely fully rehabilitated. That is what the evidence supports, but that is not the standard that he had to meet at the Miller hearing to be deserving of a term of year sentence. The Granger court defined rehabilitation as successful completion of vocational, educational, counseling programs designed to enable a prisoner to lead a useful life free from crime when released. Jason Simons is the poster child for rehabilitation. When you look at his MDOC record, the educational accomplishments, the programming accomplishments, the stellar MDOC record, he has engaged in rehabilitation. He is capable of rehabilitation. And I would argue he is absolutely rehabilitated and was at the time of his Miller hearing.
The court was concerned that he had not taken responsibility for his actions.
Yes.
That he was changing his story over the years about what had happened. At times, he would say the child followed him into the house. At other times, he would admit that he took her into the house. The court found that this continued until recently, including his interview with Mendel, when he failed to take responsibility for luring the child into the house. And the court also relied on the 2013 Compass report and the 2020 Michigan Department of Corrections sex offender assessment in coming to that determination.
Your Honor, and you beat me to the point on that one, so I'll jump ahead a little bit. That is also remarkably similar to Granger, right? The Granger court, while recognizing Mr. Granger's remarkable accomplishments, in large part imposed a sentence of life without parole because it found that he had not taken full responsibility for his crimes, which is exactly what Your Honor is talking about. Despite that fact, Your Honor, the Granger court, this court found that the trial court erred and said that that doesn't take away from the evidence of his rehabilitation, Your Honor, and that and that the fact that he didn't take full responsibility does not prove irreparable corruption, and that's from Granger. But I would also, Your Honor, strongly disagree with the trial court's assessment that Mr. Simons has not taken responsibility. And I think what's important is, you know, to look back to statements that Mr. Simons makes at the time of the crime, which is late 1994, right? And where he is at the time of the Miller hearing in June of 2023. I don't really think we can assess where he is in 2023 because of statements he makes in 1994 when he's a child and being investigated for murder. But more importantly, I think that Dr. Mendel's testimony very much solidifies that Mr. Simons does take responsibility. He wept when he spoke to Mr. Mendel about this crime. He spoke about restorative justice, how he had committed the worst crime that could ever be committed, and the harm and pain that he caused to this child's family. So I think that the assessment that he does not take responsibility is not supported by the record, but more importantly, it is not evidence of a lack of the ability to be rehabilitated. And again, that is the standard. And I think that the case law very much supports that, Granger being one of those cases, Your Honor. Mr. Granger and Mr. Simons had remarkably similar MDOC records. Granger had been incarcerated for 35 years at the time of his hearing, Jason 28. And actually, arguably, Jason's record is slightly better, I would argue, because Mr. Granger had amassed 4 Class 1 tickets during his incarceration, and we know that Jason has none. He has 25 Class 2 tickets. Granger had 17 in addition to the 4 Class 1s. Neither gentleman ever had any history of violence within the MDOC. And for Jason, that is remarkable, number one, given his childhood history of abuse and neglect. But even more impressive, what we know from the record is that very early on in his incarceration, still during a time of adolescence, he was attacked and did not fight back. So even in an environment that almost invites violence and conflict, Jason has maintained a conflict-free existence at the time of his Miller hearing for 28 years. Your Honor, I think also this court was very critical of the Granger trial court, as it should be in this case, where the trial court found that Granger was likely to reoffend. There simply is no evidence of that here in Mr. Simons' case. His COMPASS assessment showed low risk of recidivism and low risk for future violent acts, which is, of course, the lowest score. No one can score no risk, because I guess we all have bad days. But there really is no violent tendencies for Jason, and that is very similar, exactly the same as Granger. And so just as this court found that the trial court erred in Granger, it should find that it has erred in Simons. I also found, I always say there's really good things in footnotes, and footnote 5 of the Granger opinion I thought was also very telling, where this court, the sentencing court in Granger, the trial court, thought it was noteworthy that the judge back in 1984 thought that a sentence of life without parole was proper. And this court said, we're really not persuaded by that because, right, the legal landscape was different then, and the court had to impose a sentence of life without parole. And I think that's an important point to focus on, because the prosecution's case and very much Judge Lincoln's findings were looking back to 1995, right, to Jason as a child, whereas now he's a grown man well into his 40s, and really ignoring the data that the court had before it, that he is capable of rehabilitation. I quickly want to touch on Wheeler, which if I'm not mistaken, Judge Maldonado, I think you were on that panel and part of the majority opinion. The facts in Wheeler are very close to those here, right? We have a horrific murder of a pregnant girlfriend, overwhelming evidence that the crime was planned out and premeditated. He had told at least one person that he planned to kill his pregnant girlfriend. The trial court, while acknowledging that Wheeler's MDOC record was stellar and evidence of rehabilitation, focused on a 2018 ticket for possessing a small table saw and thought that because Wheeler had earned this ticket while his resentencing was in the works, it was evidence that his criminality wasn't transient and that if he were to be released, he would be likely to reoffend. And this court said no, again, heavily relying on Mr. Wheeler's amazing MDOC record similar to Jason's. And that this court found that he demonstrated an immense capacity for rehabilitation. Your Honor, the prosecution has to overcome the presumption that a sentence of a term of years is, has to overcome the presumption that a sentence of a term of years is appropriate, right? That's what the default is, by clear and convincing evidence, right? The second most demanding standard that we have. Mr. Simons is a defendant, is a gentleman who has accomplished amazing feats. And you have that testimony from Ms. Caruso, the former warden and expert in MDOC corrections, the testimony from Dr. Mendel, and if you look at, I think it's pages 45 and 46 of my brief that really list the just remarkable statements that he gives regarding Jason's rehabilitation. And I believe the direct quote was that Jason is the furthest thing from irreparable corruption. That was his expert opinion, you know, if you want to sort of bottom line it. All of the cases I've discussed today and that are in the brief instruct the courts that it has to consider actual data. The data that Judge Lincoln had before her could only lead her to one conclusion, and that is that Mr. Simons is capable of rehabilitation and he is not irreparably corrupt. The prosecution failed to present any evidence to challenge the expert testimony at the Miller hearing. As Dr. Mendel said, he is the furthest thing from irreparable corruption, and I ask this court to vacate the sentence of life without parole and remand for resentencing, Your Honor. Thank you.
Thank you. Any questions? Don't leave.
Sorry,
Any
Judge.
questions? I need to do my job.
I'm sorry.
No
My
questions? Okay. You have plenty of time for rebuttal.
Thank you, Judge.
Thank you. Good morning.
Good morning, Your Honors. May it please the court, Jennifer Rossi, Assistant Prosecuting Attorney from Calhoun County, representing the people. In People versus Taylor, the Michigan Supreme Court clarified that the prosecution is not required to prove a particular fact at a Miller hearing, including whether the defendant is irreparably corrupt. Rather, the prosecutor must rebut the presumption that life without parole would be a disproportionate sentence. Here, consistent with Taylor, the trial court followed the procedures set forth by the legislature, considered all of the information before it, before taking into account the defendant's youth at the time of the crime, the Miller factors, before determining that life without parole was a proportionate sentence. In light of the record below and the trial court's ruling, which the people submit reflects thorough, thoughtful consideration, the trial court's decision was not an abuse of discretion. And the people are here today respectfully requesting that this court affirm the defendant's sentence. This case is one of the rare cases that warrants a life sentence. As the original sentencing judge said at that time, what the defendant did is simply incomprehensible. It reminds us all of how truly depraved some of us can be. With that, I will like to ask that the court ask me any questions that it might have.
Panel have any
I
questions?
understand that the brief I wrote was lengthy. I thank the court for accepting it.
I have a question. The court considered the fact that the defendant did not take full responsibility at this point in time for what he had done, both in relation to Miller factor number 5 and considered it as an aggravating factor? Can the court do both?
The court explained that it was that it was a complex and complicated issue, and that factors that were related to rehabilitation were also revealing concerning information to the court. Things that were intended to assist a court in making a parole or sentencing decision, such as the recent Compass report, the sex offender risk assessment, actually revealed information to the court that was concerning. In particular, statements that the defendant made at this time were concerning to the court, such as when the defendant spoke to Dr. Mendel, he still showed signs of PTSD with dissociative aspects. And in particular, the way he described the offense, which was recent and not different from he has all along and historically, he fails to account for his actions, the depravity of them, and the way he described the offense to Dr. Mendel as he was trying to comfort the victim as he committed this assault was particularly disconcerting, and a failure to recognize his part in this horrendous crime and his actions. So that was concerning to the court, that he has not changed his thinking or his failure to account for the depravity of his conduct and what he did. Therefore, that was concerning to the court, understandably so.
I may understand that, but it seems like the court considered that both in relation to the Miller factor and as an aggravating factor. Is it your position she can consider it for both?
I believe that the court explained that it was the way she said it, as things that were intended or related to rehabilitation, which revealed this information, which was of concern. So the information that was before the court that is used to make rehabilitation decisions actually contained information. She stressed the statements that the defendant made at those times were what was of concern to the court. Therefore, it was the information that came out of those sources from the defendant that was of concern to the court.
All right, thank you.
Any other questions? Any questions? Thank you very much.
Thank you. I ask the court affirm the lower court sentence.
Great. Congratulations.
Thank you, Your Honors. Just a very brief response. Judge O'Brien, to your question, that is, of course, an argument that I make in the brief at about pages 33 to 34 of the brief. As I said, I was trying to narrow my argument before the court, but you know, as opposing counsel said that there was no abuse of discretion, I think Your Honor has now identified a second area where the court abused its discretion by considering facts about the case as aggravating, which of course is a Miller factor, which can either only be neutral or mitigating. But then again, just to reinforce the fact that Judge Lincoln thought that the burden was for Mr. Simons to demonstrate that he was in fact fully rehabilitated as opposed to being capable of rehabilitation is a mistake of law, which is an abuse of discretion. I also just want to point out one thing. The prosecution in its brief, it does not cite to a single case in which a juvenile offender, a Miller defendant, has a similar institutional record, a similar type of psychological evaluation where a sentence of life without parole has been affirmed. It does not exist, and there's a reason for it. It's because when you have a defendant like Jason with the type of history that he has and the expert testimony that was presented at his Miller hearing, a sentence of life without parole is just not sustainable. It's not constitutional. And that's why the prosecution has no cases to cite that are analogous or similar to Mr. Simons, where LWOP, a sentence of LWOP has been affirmed. I agree with the quote that a trial court does not have to find a particular fact, but that does not do away with the case law that says if Mr. Simons or any defendant is not irreparably corrupt, then a sentence of life without parole is disproportionate and it's unconstitutional. Your Honor, I ask again that this court find that the trial court erred, vacate the sentence, and remand for a sentence of a term of years. Thank you for your time and consideration today.
Thank you both very much. Well argued, well briefed. The matter is submitted. Why don't we take a break? Well, yep, so that we can have our media folks gather up.
All right.
Thank you, everyone. You can be seated. And we'll take item number 1 on the docket, which is case number 368-264, People versus Michael Leon Stokes. And I understand that Mr. Strauss is the lone person endorsed for argument, and he is joining us by Zoom. Hello, Mr. Strauss.
Oh, good morning.
Good morning. Great to see you.
Oh, definitely. Yeah, same here. Really not much to say. We both agreed. I appreciate the consideration by the court. We both agreed that the case should be remanded. We filed supplemental briefs. The court should be the case should be remanded for resentencing as a third habitual in this case. And I have nothing else to add to the other issue I raised in the brief,
Thank you. We appreciate that the supplemental briefing happened. That was helpful.
Oh, yeah, I
Any-
appreciate it.
No.
Any questions?
No.
All right. Thank you. We understand. We thank you and have a great day.
Okay, I think I have one more, another
Oh,
unopposed.
you do. My bad. Please go right ahead.
I'm not representing Mr. Woods. In that case, I would rest on my brief in that matter.
We have to call it though.
Yeah, we're not
Oh.
there yet.
Oh.
Let me submit this we're going to submit this case, and then I will call Mr. Wood's case next. Anything else on Mr. Stokes' matter before I do that?
No.
Okay, thank you. Then that matter is submitted, and we will move on to item number 2 on the docket, which is file 372664, People versus Cantrell Woods. Mr. Strauss, you are solely endorsed for oral argument here as well.
Yeah, I would rest on my brief in this case. I have nothing to add.
Any questions for counsel?
No, thank you.
No, thank you. Thank you very much, Mr. Strauss. Then we will submit this matter. Does
thanks
this
again.
your time on Zoom with us?
Okay.
Okay, bye-bye. Calling next, item number 3 on the docket, case number 370317, People versus Jessica Michelle Engelbrecht. And all parties are endorsed for oral argument. Counsel for the defendant is endorsed for remote oral argument. And oh, we can see a shadow of you, literally.
Carol, let me just turn the screen over. I
Okay,
apologize.
that's okay.
It might be better like this.
Better.
Thank you. Yes.
Yes, good morning, Your Honors. My name is Cecilia Carandongo. I represent Jessica Engelbrecht, who I believe is present in the courtroom, along perhaps with some family members. I did, on this case, present 3 issues for the court to consider. I do believe this particular case is very fact-driven, and very also driven by the testimony and the exhibits that were admitted during the trial. It was a very lengthy trial. I did for the sufficiency of the evidence, I know, and the people are disagreeing with me, of course, on all of the arguments, but I did want to just, I guess, remind the panel that there were testimony that was elicited that supported perhaps lower amounts that were not accounted for anywhere in the accounting that was reviewed and the documents that were submitted. I do believe that based on the amounts, which quite frankly were pretty close to the charged amounts, so meaning, a bit over 1,000, perhaps a bit over 200, but less than 1,000 for one of the other counts, that based on the discrepancies and the confusion about what cash payments had been received, what kind of other services had been provided by Ms. Engelbrecht to the various clients of hers, that there was not sufficient evidence to sustain the convictions because all of those are, amount specific. In addition to that, for the commingling of funds count, I did argue that there was not sufficient evidence to show the funds were commingled. There was no specific requirement for the charges that Ms. Engelbrecht needed to keep separate account for each client. And I don't believe that there was evidence.
Counsel, I think the problem of commingling is when you put it into your own personal account and you have another person on the account.
Well, and I understand the argument from the people in regards to the, her mom was on the account too. Her mom was assisting her, but I don't think that there was any evidence that she benefited, that they benefited from those funds being in there. But I understand what the prosecutor is arguing on that charge.
I'm having difficulty understanding your perspective. It seems pretty cut and dry what commingle is, regardless of what may have ultimately happened. And who benefited. So can you maybe tease that out a little more for me? Because that doesn't,
Well,
I don't understand.
I apologize, Yana. I think for purposes of that argument that, the account was used solely for the business from what I could gather from the evidence. And I think that that's the difference. I don't think the evidence supported that it was utilized for some kind of personal benefit either, So that's my argument. I understand what the court is saying. There was, like her mom was on there. I can't, dispute that. However, I think the account was used solely for the benefit of this business.
Okay, thank you.
In regards to the ineffective assistance of counsel argument, I do think that I briefed that out, but it revolves around the same argument in regards to the amounts, that as there was not sufficient evidence, in the first argument to sustain the convictions. In the ineffective assistance of counsel, my argument is that the trial attorney should have asked for the lesser included offenses, which the ones that I mentioned in there would all have been misdemeanors as opposed to felonies. Since there was a dispute about the amount, I think it would have been appropriate to ask for those, and also that it would have or could have made a difference in the jury's verdict had they been presented with the choice of a lesser included offense, given, quite frankly, I want to say the limited evidence supporting the actual amount of the loss. And that wasn't requested. I believe we could show prejudice as well because it led to the convictions for multiple felonies that reasonably could have been misdemeanors beyond a reasonable doubt.
Benito has a question for you.
Yeah,
I'm sorry.
Can you rebut the opposing side's argument on that issue?
Your Honor, I think, I would rely on my brief for that one, Your Honor. Like I said, I think there was a reasonable likelihood that she could have been convicted of lesser offenses on that. And I think that, they're arguing that there was, sufficient evidence for to support the convictions for the higher amounts. But I think she was entitled to the instructions.
I mean, maybe I'll lay it out and be a little bit more specific on the issue of whether on the choice of the attorney in that matter to go all or nothing. Like the defense was that she was completely innocent. And as the prosecutor laid out in his brief, to undermine that by making a request for another a lesser included charge, that might have undermined that argument. So I was asking you if you
Yep,
could
sorry.
rebut his argument. That's okay. No, I'm sorry.
no.
I wasn't clear. I apologize.
No, so I don't think that, so we're going back to trial strategy, and I don't think that that would necessarily be trial strategy either. To, you know, you can argue all or nothing and still give the jury a choice. And I think as a, you know, I'm a trial attorney too, right? And giving the jury choices, especially in a case where the amounts were highly disputed, and there was evidence supporting that they couldn't, you know, meet those amounts. I don't believe that it was a sound trial strategy not to ask for the lesser included, even if you were going with all or nothing. I mean, you can, you know, the jury can, you know, render inconsistent verdicts, or, you know, the jury can basically make the choices that they will. Of course, if the jury had believed, you know, that it's kind of tiered, if you will, the jury could believe that Miss Engelbrecht was completely innocent of everything, and then they would have found her not guilty, regardless of whether she was charged, you know, with a higher or lower offenses, right? But they could also have believed secondarily that perhaps she was guilty of something, but they couldn't prove the amounts. Well, when you're not presented with the choice of a lesser amount, a jury who are not lawyers, you know, most of the time, at least, you know, they might settle for the higher charge because they don't have a choice. And I think in a case where the amounts, like I said, were disputed and the evidence, quite frankly, was conflicting on what the actual amount of loss, if you will, were, that it was completely unreasonable not to ask for the lesser offense. I don't think it could be construed a trial strategy, although I understand what the standard is. I know that we give great latitude to trial counsel and their decisions, but because of the specific facts of this case, I don't believe it was reasonable. And even under like an all or nothing approach.
Thank you. I'm glad I clarified so that you
Sorry.
didn't. No.
I
it's
promise
good.
I was listening. Yes. And then in regards, you know, so I'll rest on my brief for the third argument, which was in regards to admitting the business records. I think it's a clear legal issue. I argued, you know, my point. I think the problem, well, we all know what happened. You know, Ms. Myers was in no condition to testify. And so her husband took over. He had not witnessed these being prepared. I don't believe that he could really testify that those records, you know, were done in the ordinary course of business with these particular clients. He just didn't know. He knew that granted, he recognized her handwriting. I don't dispute that. He could say that his wife authored those, but I don't think the authentication for a business record, those requirements were not met, in my opinion. I understand the prosecutor's argument, but we differ, I think, on the legal standard for what is a business record. And I think without those records, there were issues with at least two of the counts, which I believe would be counts 1 and 2, because without those records, there was really nothing supporting you know, the amounts charged again. So I do think we could show prejudice on that too, at least for 2 of the counts. And I think if you then have issues with 2 of the counts, it puts in question, you know, the whole case, which was why I asked for a new trial based on that argument. And with that, I would rest on my brief and the arguments I presented in there, unless there are any questions.
Any other questions? Yes. All right, thank you. You have some time.
Thank you.
Good morning.
Good morning, Your Honor. Good morning, Your Honors. Dan Gunderson, Assistant Attorney General, appearing on behalf of the appellee people of the state of Michigan. I'd like to kind of follow in reverse the order that appellant counsel laid out. For the record, I do want to note that the appellant pronounces her last name Engelbrecht. With regard to the lesser included instructions that Judge Maldonado asked about, appellant counsel says there's a dispute as to the amount. there isn't a dispute as to the amount. Various levels of the amount were given by different prosecution witnesses. All of those exceeded the statutory charged amounts. Questions by trial counsel are not considered evidence. So there is nothing on the record that undermines the amount given by the expert. I believe in trial exhibit 41 that states.
I don't think that's what she's saying, and you can correct me if you think I'm wrong. But I think she's just saying that different people testified to different amounts. But I think we also understand that they were saying, well, this person was giving the benefit of the doubt, or this person was measuring by this. We understand how it was cut.
Okay, thank you. And in terms of whether or not it's appropriate for the jury to have made that decision, or I'm sorry, for the trial counsel to have made that decision, we cited People v. Klein as well as People v. Allen, which cited Nixon and Robinson, which stand for the proposition that making that determination was all or nothing, as Judge, you referenced in your question, is an appropriate tactical strategic decision that trial counsel made. With regard to the sufficiency of the evidence argument, here, again, appellant cites no cases supporting her position aside from one stating that this is a specific intent crime. But contrary to her factual assertions of credit not being given for certain expenses, that the record doesn't support that argument. It's clear that credit was given for the expenses by the people's expert. Specifically, counsel referenced in her brief GameStop expenses, pharmacy bills, boots and a cowboy hat. Those were all in People's Exhibit. I'm sorry, I have to correct what I said before. People's Exhibit 49, it was on page 41 of our brief. Those were all given credit for by the people's expert accountant.
I was going over my notes again last night in preparation for today, and I didn't have a note on the car. Like, I know the car was used. I know the title was changed. I know no money, like it was supposed to be $600. It was supposed to be transferred into an account, and that did not ever happen. Was the car charged any? That's what I don't have notation on, and I couldn't find it in the time I had last night to put that back together in my own mind.
Yes, the car was not included in the expert's tally. We did ask the jury to include that, to tack that on at the end, but the accountant did not address that specific car expense in her expense tally.
Okay, thank you for that clarity. That's why I didn't have a note.
Now, okay, if towards the appellant counsel's assertion in her brief that there weren't records sufficient in evidence for the jury to make that determination, the appellant's bank accounts were admitted at trial. And as to whether or not she received a benefit, that was another one of the appellant's arguments. I can name three different benefits. One being a direct kind of Russian doll benefit that the defendant appellant received, and with specific reference, Judge Maldonado, to the car. She received different layers of benefit from that. First, she received a car. She did not pay for the car, even though she blue booked it at a specific expense. And then she also admitted that she took money from victim WP to detail that car so it was nice enough for her personal use. So personal use of a car, the price, and then the detailing, those are all a direct benefit. There's also general evidence of a direct benefit in that looking at the expert accountant's testimony, we have her stating that as the appellant's bank account decreases, money is taken from the victims, especially from victims RK and victim MW from count 2 because they had the most money. So that's a direct benefit. And then in terms of an indirect benefit, which can also be used for the embezzlement counts, you can also look at victim MW from count 11, not from count 2, where he actually receives money. Now, defendant appellant says that that should be counted for her, but it doesn't, because the indirect benefit of that is that she's able to disguise the fact that she's taking money from them. And because as soon as he doesn't make his rental payment, there's an APS case. Then it's apparent that she's taking from her other wards. So that could be seen as an indirect benefit. And the appellant acknowledged in her interview that there were questionable expenses as part of her bank records. I'd like to turn to the commingling account. In response to the appellant counsel stating in response to your question, Judge Rick, that she didn't receive a benefit from commingling. That's not a requirement of this charge. There is no requirement that the appellant receive a benefit. The crime is completed as soon as the monies are commingled, borrowed from, or pledged to.
I wonder if you might talk about this, and then council will have an opportunity in terms of rebuttal. I mean, there are two statutes at play here, 750.145 P1 and A indicates commingles, borrows, or pledges funds that are required by law or administrative rule to be kept in a separate account. And there doesn't appear to be any guidance in terms of established law, but we know under a separate provision of this pertaining to EPIC that guardians and conservators are considered fiduciaries, and that under 700.12121, fiduciaries must keep a segregation or must hold assets segregated, held in the fiduciary capacity. So that being said, I mean, would it be helpful, first of all, to officially enunciate and link those two provisions together? And how do you see those provisions working in tandem to support the argument you're about to maintain?
Absolutely. I think it would be very helpful from the court to hold that those are linked in this case. And how would I articulate how the statutory scheme? Okay. She is required to keep them separate. Conservators are explicitly considered trustees in their governing statute, which is MCL 700.5416. That standard of care would be completely meaningless if it did not impose, if it imposed the duty of a trustee without there being something held in trust. Now, the appellant does not do this on appeal, but the trial counsel attempted to draw a distinction using the phrase trust account. But that doesn't have a strict definition, as you note, Judge Rick. The best one I think that the court could look at in terms of kind of layman's language would be from the Michigan Model Civil Jury Instructions. And that specific instruction is 179.02. And it says, a trust is a fiduciary relationship with respect to property. The person with title to the property has certain duties to hold and deal with the property for the benefit of another person. So that's kind of a more generalized definition of trust. And that's what I would argue is required here. The statute doesn't require the drawing up of some kind of revocable or irrevocable trust document. That would be in the appointment of a GAL in a long legal process. but trial counsel used the example to draw a distinction of an IOLTA. And I like this example. I think it actually helps us because part of the acronym is trust account, and it's, created by lawyers. But it isn't a trust account like an irrevocable or revocable trust. It's more similar to something like a title company's escrow account. That idea being that the money is at the very least tracked and segregated, as Judge Rick, you noted, if only from the lawyer's own. And that was not done here from the guardian/conservator's own money or her mother's money. And it is required. And for guidance, the court can look at administrative rule as applied to other caregivers that are regulated by this commingling act. And that administrative rule is 400.1421 as cited in our brief. And that merely states that the accounts have to be kept, quote, separate, unquote, and held for, quote, safekeeping, unquote. That is not the kind of specific definition of trust that the appellant might be asking this court to adopt had they articulated that in their brief. What it is the same definition that applies to guardians and conservators as fiduciaries. And that's just segregation of assets under MCL, as Your Honor stated, 700.1212 sub 1.
Does it matter to you? To me, it seemed rather important that not only was the defendant on the account, but her mother as well. Do you have any thoughts along that, a response to that concern?
I think so. I think that is important. I don't think it's outcome determinative necessarily, but I do think that's a very interesting detail in this case. Now, there's no evidence, again, that the mother was taking money out of that account. But as I stated previously, benefit is not required here. It's just the commingling, pledging, or borrowing.
Go ahead.
It did seem like this was a close case to charge, like just from reading the workup that that the two of you presented on this, it seemed like even the police officer was on the fence about presenting it for charges. Is that a correct kind of characterization in your view?
I don't think so, Your Honor. In fact, the police officer asked for this charge. That's not, I don't think, apparent on the record. So take that for what you will, but I can say that is what occurred. So I think that also I did want to note that the other guardians who testified were clear on their responsibility. So whether it's close or not, I think it's at least notorious in the guardian conservator community based on the testimony at trial that they knew they couldn't do that.
This is her first guardianship, correct?
Yes, but they did not occur at the same time. So
the very first one is in this batch that she did.
correct. I believe
Okay.
it was RK, victim RK was the first one. So Guardian H said, testified, well, I believe you're not supposed to intermingle funds with each other. Guardian T testified when asked, you didn't put all their money in the same account, said, no, how would you? No, you can't do that. So those are examples of guardians who are aware of their obligations. And I think that's important to the court's analysis in this case. I think from a statutory construction perspective, it also weighs in favor of the people here. And here, the appellant is asking this court to not only strike out or redefine other responsible person from the statute or other person with authority, excuse me. They also want you to write in that new definition of trust account saying it's a revocable or irrevocable trust with a governing document. And I don't think there's any support for that position.
Any additional questions?
Anything
else?
If I can quickly address the No, I think that's it. I'm sorry. Thank you very
Okay,
much.
Thank you very much. And we now have time for a brief rebuttal.
So just ever so briefly, maybe to address those, actually, maybe also the very last comments. You know, there's a difference between violating the rules under the probate code, which, you know, may violate, you know, whatever duties you had in probate court, which then may lead to you being removed as a guardian, and then being charged under the criminal code with, you know, a variety of crimes. And I think that's the problem in this case. And, you know, when it's being brought up, what this was her first batch of guardianships, it absolutely was. And it was also part of, you know, the argument in the brief that you know, there was no indication that anyone had received training, anyone had taught my client how to do any of this, that she'd ever been given any rules on how to act. You know, and like I stated in the brief, I think it's pretty clear that, you know, there was sloppy accounting, that there was perhaps a certain level of ignorance in how to, you know, probably record keep. But that doesn't mean, well, first of all, I think it leads to not having the required intent for the crimes, which is one of my arguments, which I think I did cite the standard for that and supported it with the facts. But also in regards to the commingling of funds, you know, there's no requirement, maybe under the probate code, but then the statute should say you commingle funds by violating, you know, the epic guardianship rules or whatever rules in the probate code. And that's not the language. And I think it's an important distinction. So maybe then the language needs to be changed. But that's not what she was charged under. Ms. Engelbrecht was charged, you know, with crimes, not simply with violating the probate code or maybe the duties, you know, that you have in probate court. And I think that's very important in this case. And I do agree that it, at least there should, they maybe they really wanted to charge her with crimes, but quite frankly, I think it was an exceedingly close call for me, which is why I presented the arguments the way that I did. You know, I don't think this was a case of someone who had the specific intent to defraud or commingle or, you know, or do any malfeasance against these folks that she was charged with taking care of. And I think the facts, even the testimony at trial, supported that idea.
Is
So,
Karen
yes.
Dongo, I mean, it is, you have to admit, though, it's a rarity that a probate judge and or his staff goes out and retrieves the car or assets on behalf of these guardians. I mean, that's extraordinary.
You know, I don't know. So I live in a really large county. I would think that it's probably a rarity here. I was actually shocked when I learned on this case the way that that particular county was appointing guardians, because my client didn't have any training. I've never seen that in my county. You know, so I don't know if I can say that. I don't know. What I was mostly shocked about, quite frankly, in this case, is how that county was appointing guardians, which clearly Ms. Engelbrecht received no training before being tasked with taking care of folks. And that's not on her. That's on the court, and it may have violated, you know, whatever probate code rules or, you know, whatever, but I don't think that makes her a criminal. And I think she, under the circumstances, she did the very best she could. So, and the car is only for one person. I also just want to point that out. So there was tons of other charges on that one. But I would say, yes, in Oakland County, I think it would probably be an extraordinary measure, but I also don't think Oakland County would have professional guardians who had received zero training.
Thank you. Anything else you want to say? Or are you concluding your rebuttal?
No, Your Honors, thank you.
All right. Thank you both for a very informative argument. This matter will be submitted. Have a great day.
Thank you.
And now we're up to item 6, Four Lakes Development. versus Cass County Road Commission, and that's docket number 372405. Looks like Attorney Asher is joining us remotely. And counsel who is seated at the appellant's table, are you dividing your time or are you?
I'll be arguing just.
Awesome.
So-
Thank you. Then you can proceed. Thank you for not having me get out the stopwatch, which I truly hate doing.
No one likes that. Good morning and may it please the court. Brian Doyle on behalf of the appellants. My partner Regan Gibson is with me. It's our pleasure to be before the court this morning. Your honors, in the end, this is not a complicated case. It does not involve novel or controversial issues of law. And it's not a close call on the central question, which is, does my client's property have riparian rights? The answer to that question is a resounding yes. Of course, their property has riparian rights. And I want to jump right into that question this morning because that's the central question really with which everything else flows, all the sub issues on this appeal.
Close. Got it. That's good.
Thank you, Your Honor. So let's start with what we know, what no one can deny. This is riparian property. The deed for these properties goes to the water's edge. So it's riparian property. And that means by operation of law, it has riparian rights. That includes things like the right to maintain a private dock, the right to dock a boat or have a boat on the bottomlands. So undisputed riparian property, and under the law, riparian properties are come endowed with those riparian rights.
Unless.
Unless a contrary intention of the parties appears. That's the one exception, and I will get there, Your Honor. I will cover that. But I want to talk about, when we talk about the foundation here, what else do we know? This property has a roadway easement on it. That means a few things. It means the public can travel on that roadway easement. It means the road commission has the right to maintain that easement. And because this roadway easement is at the water's edge, it goes to the water's edge, it means the public can access the waters from that easement. Here's what we know it does not mean as a matter of law. A roadway easement does not give riparian rights. And that is, one example is your decision in Dieball v. Lennox, 260 Mishap 698. A waterfront easement like this gives access. It does not bestow riparian rights. So here, again, this isn't a complicated scenario. We have over 11,000 inland lakes in this state. There are thousands and thousands of people, property owners in this exact same scenario. They have riparian rights and they have an easement.
This is a very unique piece of property because you have an unappealed decision by a prior court, actually have two of them, right? That are about this exact same parcel.
There are two.
That makes this particular piece of property different than every other piece of property.
This property is different in that it's been litigated more than most, but those prior decisions have nothing to do with riparian rights. And that's a key distinction before this court. This case is a common scenario in that it's like so many other properties in this state. And we cited to you in our briefing numerous cases just like this case, the Thies case. The backlot owners had an easement so they could access the water. They did not have riparian rights. The Delaney case, the same thing. There's the public with an easement, but no riparian rights. The Krantz case, the Croucher case. So what's different here? That's the question. What's different here than all these other cases where a riparian property has an easement that allows access? Our position is nothing's different. Our client wants the same rights that every other riparian property owner has to maintain a private dock. What does the road commission say, Judge Maldonado? The road commission, Maldonado, I'm sorry.
Okay.
The road commission says the Rathfon case, one of the two cases that you mentioned involving this property, the road commission says the Rathfon decision stripped this property of its riparian rights. That's the road commission's position. The road commission says the Cass County Circuit Court in Rathfon divested the riparian rights from this property and bestowed them, granted them to the public at large. The problem, of course, is that the Rathfon opinion says no such thing. Let's jump right to the holding of Rathfon. Where does it say in the holding of Rathfon, I hereby divest and strip the riparian rights from this property and I hereby grant them to the public? That holding's not there. The holding in Rathfon is incredibly limited. It says, and the dispute in Rathfon was incredibly limited. It was, what is the width of the roadway easement? Is it 20 feet, only 20 feet as the property owner at the time argued? Or is it 55 feet to the water's edge? And the court in Rathfon held this easement is 55 feet. It extends to the water's edge. That is the sum and substance of the holding in Rathfon. So, okay, there must be some discussion of riparian rights, at least in Rathfon. If this is the road commission's case that supposedly divests this property of its riparian rights, there must be some discussion.
Some discussion, because there, some of the things that are talked about in there include, if I remember correctly, boat launching, washing cars by the side of the road, swimming, those things. And then in the next case, what is it? The Comstock, is that right?
Well, the dot case is the case, yes.
That case, the judge specifically reads the prior case as a riparian rights case.
I disagree with you on that. And I don't want you to take my word for that. I want you to take the road commission's word for that. In the dot case.
I like the judge's word for it when you read the transcript for the dot case.
Well, the holding of dock is again about the width. The issue in dock was again about the width of the roadway easement. That was the issue before the court. Was because what happened in dock, new land was created, a break wall was installed. And so there was new land that was created along the edge of the lake. And
Quite a bit.
yes. And so the property owner said, well, the roadway easement was only 55 feet. It doesn't extend now to the new edge of the lake. And what the court in dock said is water's edge means water's edge. So it was again about the width of an easement. And that was the court's holding. The court did not hold this property lost its riparian rights in Rathfon. You won't find that language. You won't find anything that suggests that. It's about what is the width of the easement. And here is what the road commission, who would know better than anyone, it was the party to the case. Here's what the road commission said in its briefing in the dot case. Quote, neither the prior Wendt nor the prior Rathfon cases were about riparian rights as such. They were about the location of Eagle Lake Road. Likewise, the present case, the dot case.
Would you agree though that statement about Wendt is clearly wrong?
I would not.
That's the defense case, right?
Correct. There were two Wendt cases. There was Wendt 1 and Wendt 2. Wendt 1 was just like Rathfon. How wide is the easement?
The fence goes in the water and prevents the public from utilizing their riparian rights in the same manner.
I fundamentally disagree with that statement. And again, we have to keep in mind the distinction between an easement and riparian rights. The public here has the right to access the lake. They can go off the easement and into the water. They can swim, they can pass through, they can fish. That does not mean that this property was stripped of its riparian rights. Those are two very distinct legal rights under Michigan law. And as I said to you earlier, it is black letter law that the fact that I, as a member of the public, or I as a member, another property owner, right? Like another property owner can have an easement to access water, right? I have the right to access. I do not take someone else's riparian rights just because I have the rights to access. That's the issue. And look, Rathfon, the circuit court in Rathfon understood riparian rights. If it wanted to take a property's riparian rights and give those rights to someone else, it would have said so. It did not say that. It said the public has the right to access the waters. The public has the right, of course, to use the waters. Once they get in the water, they can swim. Yeah.
I'm not a land attorney, but my understanding of easements is you're not stripping anybody's rights.
Exactly.
Two sets of rights coexist at the same time. So kind of the phrase stripping suggests that, when you have an easement, you're taking something from somebody. You might, the way I read it is you're, limiting it so that both have the same, you know, if we're talking about the roadway, right? That, you know, the owner of the land, let's say we were just talking about the road, right?
Sure.
The owner can't do anything that would prevent the public or the, you know, whoever's in charge of taking care of the road from doing whatever it is that they normally did, right? Using the road, repairing the road, that kind of stuff. That's a lot of stuff that you're not allowed to do anymore. You can't build a fence, you can't, you know, can't charge, well, maybe you can charge still, but nonetheless, you're still not stripped of your right or your ownership of that property. So I'm confused by using the word strip.
Well, that's what the road commission is saying in this case, and leave no doubt about it. They say Rathfon took away this property's riparian rights. I agree with what you just said completely. That's what my client is looking to return to, the status quo. That's how this property was treated for 70 years, where the property owner had riparian rights, they maintained a private dock, and the public was able to access the lake.
Yeah, the public, but see that there was a sea change that was proposed. I agree with you. Like it was fine to have the dock there and charge the public. That's being allowed apparently on a couple of properties. But the sea change was the seasonal docks that were being proposed to be put in place were going to be closed to the public.
Correct.
So you're taking away, so prior, the public could use the dock. Maybe they have to pay, but they still had access and still could use it as in the way that they had been at the time of the opinion. But then when you install the private dock, you are taking something from the public that was there before.
The public, I disagree with that. There's been various docks there over the years. There's no indication that those were ever public docks. The factual record in this case is that they were private docks. That's why, like, if someone wanted to use it, sometimes the landowners would, over the course of time, different parties owned this land over different periods of time. Some landowners charged to use the dock. Others just had private docks.
I mean, this whole thing started because wasn't your client gonna build a dock and they didn't give them a permit, right?
That's exactly correct. A riparian property owner has the right to maintain a private dock. That's the law. So unless those rights were stripped. And so that's what you have to ask yourself. Is there a circuit court decision?
Or abrogated.
Sure. Is there a circuit court decision? Is there some event that stripped, divested, or abrogated riparian rights? There isn't. The Rathfon case didn't do it. If that was the opinion of the Rathfon case, it would say it. If that was the opinion of the Rathfon case, the road commission would have not said in the next case, likewise, the present case is not about riparian rights, just like Rathfon. The road commission itself said these cases are not about riparian rights. And so the Rathfon case does not support that holding. Well, let's look at Michigan law more generally, okay? Let's take a step back. Is there any other case that says the establishment, because that's what Rathfon did. Rathfon said there is a roadway easement to the water's edge. That's what Rathfon did, okay? Is there any case under Michigan law that says the establishment of a roadway easement divests, abrogates, takes away riparian rights? There is not a single case that does that. There's not a single case in this briefing that does that. In fact, the law is just the opposite. In the Baum case in 2010, the Michigan Supreme Court said, in our jurisprudence, in our body of law in this state, no court has ever held that the establishment of a public road through dedication, through easement, has ever taken away someone's riparian rights. What it does, if the Rathfon case had not held that there was an easement to the water's edge, the public could not have accessed the lake through that space. The public wouldn't have had access. The easement allows the public to access. It doesn't take away riparian rights, and riparian rights allow a landowner to have a private dock. That is black letter law in this state, Your Honor. So the law in Michigan there's not a single case that says the establishment of a roadway, an easement takes away riparian rights. There must be some case that the road commission can present where a property has lost its riparian rights under some circumstance, right? They must have a case or two where they can provide you with an example of a property losing its riparian rights, abrogating its rights. There's not a single case that they present to you under any circumstances. The most they can say is that it could happen if there's a contrary intention of the parties. That's the most they can say, but they don't even have an example of that. And in every case, Your Honor, where there is a contrary intention, the court looks to the title record. And I'll get there. There's a few cases in the briefing. The Thies case, the court looked to the language of the plat. Is there a contrary intention in the plat that this property lost its riparian rights? Haringa, quote, unless a contrary intention of the parties clearly appears from the deeds under which they hold. The Gutwein case, nothing in the deeds suggests a contrary intention. Croucher, in the absence of the intention of the parties in a conveyance. So the best the road commission can present to you after all this litigation, all this briefing, not a single case under Michigan law where a roadway took away riparian rights, abrogated them. Not a single case where a property owner ever lost their riparian rights. The most they can present to you is that if it's in the title record, if there's a contrary intention of the parties, it could happen. Well, here they admit there is no contrary intention in the title record. They admit that. And so the most the road commission can do is say, you should infer in the Rathfon decision that never utters the phrase riparian rights. An opinion that never utters that phrase, they say, divest this property of its riparian rights. Even though that's not the law in Michigan, a roadway easement cannot do that. Even though they can't present a single other case to you where this has ever happened.
Can you talk a little bit about your view of the Went case and its holding, please?
Absolutely.
Thank you.
And I'll distinguish them, Your Honor, Went 1 and Went 2.
Yeah, fair enough. Yeah, I gotcha.
Went 1 is just like Rathfon. Went 1, the property owner said the easement's narrow, it doesn't go to the water's edge. The road commission said, nope, the easement goes all the way to the water's edge.
Let me just clarify, we understand that this is a different piece of property.
Good. I was going to get there, but I appreciate that. So I would say Went 1 is indistinguishable from Rathfon with this key respect. In Went 1, there is some dicta. The phrase riparian rights is used in Went 1. The court says, we reject the property owner's argument that they have riparian rights in the strip of land. And here's the key to that, because you're going to hear about that from Mr. Asher. The key is a key distinction between the two cases. The properties in Went, the deeds did not go to the water's edge. So the court was saying those properties do not have riparian rights. The court wasn't divesting or abrogating. The court was saying, if anything, it was saying these properties, because the deeds don't go to the water's edge, they don't have riparian rights. The court, again, we all read opinions for a living. If the court was saying this property in Went had riparian rights, but because of this roadway easement, it's now losing its riparian rights, the court would have said that. Just like it would have said that in Rathfon. It didn't say that. So in Went, the holding was the easement goes to the water's edge. That was the holding. The holding in Went didn't have anything to do with riparian rights. There was mention about a claim of riparian rights in the strip that the Went properties didn't own, but the court apparently rejected that. So Went 1, about the width of an easement. Went 2, because that easement exists, the public has the right to access the lake. You can't put a fence up. That was the holding of Went 2. And again, I want to talk about 3 parties that have looked at Went 2 and have discussed what that case means. The Road Commission, this court, and the Supreme Court. So again, the Road Commission said neither the prior Went case was about riparian rights. The Road Commission said Went was not about riparian rights. This court looked at the Went case and its decision in Kempf, K-E-M-P-F, 69 Mishap 339. It looked at what the holding was and Went 2. And it said, Went merely affirmed the grant of an injunction against interference with public rights in a lakeshore highway. That's how this court viewed the holding and went to. Nothing to do with riparian rights. Access to water, access to a highway, nothing to do with riparian rights. And then, of course, the Michigan Supreme Court in 2010 in Baum. No Michigan decision has ever held a dedication of a roadway conveys riparian rights. So 50 years after Went, the Michigan Supreme Court reviewed in the Baum case as an exhaustive discussion of riparian rights. The Michigan Supreme Court affirmed 50 years after Went, no roadway easement has ever abrogated riparian rights. So my view of the Went case, different parties, different property in a key way, property that doesn't go to the water's edge and so isn't riparian, a holding that has nothing to do with riparian rights, and a holding that the Road Commission admits has nothing to do with riparian rights. And I want to say this, we've briefed this case a lot, and again on appeal. The Road Commission has never once, Mr. Asher has never once offered an explanation. Why did his own client say Went, Rathbun, Dock did not involve riparian rights? Well, it's because he doesn't have a good answer. Is he going to say that they were mistaken? I would submit that any objective reading of those opinions makes clear they are about, all of them are about the width of a roadway easement. They don't talk about what happens in the water. I guess a simple way to say it, Your Honor, is all of those cases stop at the water's edge. They don't go into the water. This is the first case that's ever gone into the water and talked about riparian rights. And not only does the law overwhelmingly support our position, the facts do as well. For decades and decades, everyone treated my client's property like it had riparian rights. Private docks were allowed. The public did not have access to those docks. If they wanted to use them, they had to pay for it. That's not a public space. The party in the dock case maintained a private dock.
Is there like a site for that though?
Yes, we cite to all of that.
No, just for the fact that if you have to pay to enter something, it's not a public, it's not open to the public. Because that would be very persuasive to me.
I don't have a site for that proposition in the briefing or at hand, but again, either this property has riparian rights or it doesn't. I just want to go back to the basics on this.
It can't have any?
What's that?
It can't have some riparian rights and it's an all or nothing proposition. Is that the argument?
Well, I'll focus it. Either it has the right to maintain a private dock or it doesn't.
Okay.
I'll focus it there, okay? And we know the default is it has that right as by operation of law. That's the default rule. So, Your Honor, you would have to find that some event happened that took that right away from this property. We know as a matter of Michigan law, a roadway easement cannot do that. So, and there's no opinion out there that says the right to maintain a private dock has been stripped from this property. There's no opinion out there that says that right's been lost. The best you could say is perhaps there's an issue of fact. Did someone gain adverse possession over a particular dock? That's maybe the best that anyone could argue here. The facts clearly will show no, but my client has the right to maintain a private dock. It didn't somehow, because of this roadway easement, gain an obligation or burden to maintain a public dock. Right? And no one suggested that. No, the Road Commission's never argued that for all time now you have to maintain a public dock.
So let's say that your client and other people maybe were charging and it just nobody was aware of that they were charging, or it didn't get reported or nobody enforced it. How would that change anything in the calculus?
I don't think those facts exist.
Yeah, we don't have anything like that.
Yeah, so I can't really respond to that.
That's fair.
What I can tell you is the record shows that for years and years, everyone treated this property like it had riparian rights, including the right to maintain a private dock. The former managing director of the Road Commission said, I reviewed the Rathfon decision, and I don't think it took away riparian rights from this property. The current director of the Road Commission was deposed. He said, I can't read Rathfon that way. Okay, so the factual record overwhelmingly supports that this property has riparian rights, including the right to maintain a private dock. And that's one of the reasons why those facts are why res judicata could never apply here. This is the first case in which riparian rights has ever been at issue. Not only was it never raised in a prior lawsuit, as the Road Commission admits, it was never in dispute. The prior managing director of the Road Commission said, I think the property has riparian rights. No one was ever fighting about this. And so under the body of Michigan law on the doctrine of res judicata, this issue was never decided in a prior decision. Rathfon or dock did not decide this property lost its right to maintain a private dock. Again, don't take our word, take the Road Commission's word. And nor was it part of the transaction at issue in any of those cases because, again, it wasn't disputed. And Your Honor, the Road Commission does not present a single analogous case that would support its claims on res judicata. We do. We present a remarkably similar case, Sheridan Drive versus Woodlawn. Two cases. One involved the establishment of a roadway easement. The second involved riparian rights. That's the Sheridan Drive Woodlawn case. In the court, this court said it's not res judicata. The first case was about an easement. The second case was about riparian rights. So res judicata doesn't apply. So again, the law overwhelmingly supports appellant's position on res judicata.
So you've got maybe 2 minutes left, inclusive of rebuttal time.
I will reserve my rights, and I really appreciate that. Thank you, Your Honor.
Welcome. Thank you. And now we will hear from Mr. Asher.
Good morning.
Good
Excuse me.
morning.
Good morning, Your Honors. Thank you for allowing me to appear remotely this morning. Leroy Asher on behalf of the Cass County Road Commission. I believe also observing, also via Zoom, is Mr. Robert Thompson, who's the managing director of the Road Commission, and Mr. Joe Bellina, who is the chief engineer. Your Honors, although I just told you that I am here to appear on behalf of the defendant and the appellee, the Cass County Road Commission, I think more accurately you could say that I am here to appear on behalf of 10-year-old Mary Smith. And Mary's a young girl in Cass County, and Mary was taught to fish by her mother, and she comes to this property with her mother and her father, and she enjoys shore fishing. She enjoys the activity. If you reverse the Rathfon decision, girls like Mary will not be allowed to shore fish because there'll be no trespassing signs put up, and there will be boats and docks, private docks, that prevent her from doing so. This case is also about a 68-year-old grandfather by the name of John Jones. And these are hypothetical people, as you might well guess. John Jones is 68 years old. He was born about the time of the Rathfon decisions. As a young boy, he went to this lake with his dad, and his dad put a boat into the water at the boat launch, and young Johnny and his dad went out and fished. And in the 1990s, as an adult with children, he brought his daughter and his son to this property, and they launched their boat and they went out and fished. And now, as a 68-year-old grandfather, he brings his 4 grandchildren out, and they launch a boat and they go out and fish. Four Lakes wants you to prevent all of that activity. They talk about the status quo, but the status quo is for 70 years, people have been fishing, swimming, and launching boats from this property. It's not the Road Commission that asked you to change the status quo. It's Four Lakes. And they do so, and they state this in their brief, for the simple reason that they can make more money if they can sell these as condominiums that have private dockage rights for the affluent people who they look to sell these to buy their condominiums. Most respectfully, Your Honor, we're going to ask today that this court affirm the public's rights. Mary and John and all of the rest of the residents of Cass County, their rights as granted by Judge Mosier in the Rathfun decision and affirm Judge Herman. Now, Mr. Doyle indicated, and I'm going to state the same thing. This case is principally about the Rathfun case and whether it grants rights. There are other issues in this case, but I'm going to focus on the issue that Mr. Doyle focused on as well. And I think I would phrase the question in this way. The question is whether Judge Mosier's intention, and this picks up on the question from the court about what is the intention, unless there's a clear intention otherwise. So the question is, what was Judge Mosier's intention in granting the public the riparian rights on this property? Now, before looking at the specific language in Rathfun, I do think it's important to just very briefly touch on the connection and how related the Rathfun case and the Went 1 case are. And Mr. Doyle's admitted that they are similar at least. First is the location of the properties. In the appellant's brief, they state that the Went properties somewhere else on the lake. And they attached a photo at page 5 of their brief that cuts off at the top of the Rathfun property, now the Four Lakes property. It doesn't show the Went property. That is somewhat misleading in the sense, and we've attached at page 5 of our brief an image that shows just where Went and Rathfun are. And the answer is they are connected. They share a common boundary. The Went property is immediately north of the Rathfun property. And together, those two properties at the time in the 1950s made up the entire east side of Eagle Lake. Second is the chronology of the two cases that were decided by Judge Carl Mosier in the 50s. The Went case was filed in 1955. The Rathfun memorandum was in late 1956. The Went, and I don't have a specific date. I couldn't find it. I couldn't see it on the thing, but I mean, I know it was in the late 56. The Went memorandum was decided November 21 of 56. The Rathfun decree was decided 15 days later, December 4, 1956. And the Went decree was January 31, 1957. So these two cases were before Judge Mosier at the same time, involving two different claims. Now with different witnesses and different proofs, but they were connected in a very real sense. So in order to determine what Judge Mosier's intent was, you have to put yourself in his shoes. He's looking at these two cases and he's making rulings. And finally, you can see the connections in the opinions and the memorandums that Judge Mosier issued. If you lay those two memorandums side by side, and I would encourage you to do so, you can see just how similar his opinions are. Specifically, as to this most important issue, and I'm now reading from the opinion, and this appears as the appellee's appendix at page 78 of their appendix. It's page 4 of the Rathfun opinion. On that page, Judge Mosier, after describing the property, says, quote, "The strip of land between the road and the water has been used for a variety of purposes, including the launching of boats, swimming, shore fishing, parking and washing of automobiles, and this has been constant and over nearly all of the land in dispute." Now, what does Judge Mosier say in the Went case? In the memorandum in Went, and this is now I'm quoting from—
Mr. Asher, may I ask you, I've got the exhibits pulled up. Could you direct me again to the pages that you're referring to, please?
Certainly, yes. From the Rathfun case, the Rathfun case appears, the first page starts at page 75, 075 of appellant's appendix. And
Thank
the
you.
page I read from is page 78.
Thank you.
Okay.
That appellants and not appellees?
It's appellants.
Okay, thank you.
Yep. The Wendt case, the memorandum in Wendt appears, Your Honor, starting at page 566. And again, this is of appellant's appendix, not appellees. And the language I'm going to read to you is from the third page of that opinion. It's page 568 of the appendix. And very similar to what I just read you from Rathfun, the court states, but not quite exactly the same words, but very close. Court Judge Mosier states, the testimony showed that the public has used the strip of land between the road and the water's edge for a variety of purposes, including the launching of boats, swimming, shore fishing, parking of automobiles, and the washing of cars. And this use has been constant over nearly all of the land in dispute. Now, just as a very quick aside, Mr. Doyle said, well, these cases are different because the description of the land on the Wendt property only goes to the road, and the description of the Four Lakes property goes to the water. But most respectfully, in reading this opinion, in the Wendt case, I would most respectfully submit that at the time that Wendt owned the property, and Wendt's property was later subdivided, and there's now about 15 houses where Wendt's property used to be. At the time Wendt was decided, the court is addressing this as though Wendt had the riparian rights and had rights all the way to the lake. That's, I believe, what was the facts then. What they are now in terms of ownership and how the deed reads, I can't comment, but I don't think it's relevant to the issue that's before this court.
Well, can you please, he doesn't have a ton of rebuttal, so with a question, I think it's pretty relevant. I think one of his strongest arguments is that the holding of the cases that you cite are not specifically about riparian rights. Can you address that?
Yes, and Your Honor, I would agree. I think and I would also agree that the word riparian appears in the Wendt memorandum and does not appear in the Rathfun one. But most respectfully, I think the holding, and I think the intention of Judge Mosier, and we are talking about intent, the intention of Judge Mosier, why would you include the language describing the strip of land and what the public has done and what the public can do? I think that language, most respectfully, grants the public the riparian rights. I mean, Mr. Doyle made the argument that, well, the people can swim, they can get out in that water and swim. But the answer is, except the Four Lakes says that they own the bottom land. So as long as you don't touch down and don't put your feet on the bottom, you can swim in the water. You can access it and jump out into the lake. Just don't stand. But more than that, and I say that somewhat with a joke, as you can tell, but more than that, think, and I'm not a boater, but I've been around boaters and I've helped get boats in and out of the water. And I'm sure the three of you have at least observed that if you're not a boating person. How do you launch a boat without standing on the lake bottom? How do you, if you picture the activity, it's somebody usually pulls up with a car or a truck with a boat on a trailer on the back of it, and they back the boat trailer into the water, riparian water. They back the boat trailer into the water. Somebody jumps out, they stand, they help get the boat off of the trailer and the truck pull away, and the people enjoy the day out boating. And when they come back, somebody's also standing in the water to do this. Four Lakes erected boulders and riprap and stones and various things and completely blocked that activity. Judge Mosier said the public has been launching boats And Judge, I would agree with you. He doesn't specifically say riparian, but when you read these together, I would most respectfully say that they have those rights, and you can't launch a boat without having riparian rights. That is a physical impossibility. You can't levitate the boat into the water and make it jump off your trailer. Now,
Can I ask a question, Mr. Asher? What I find confusing here is that if you look at the history of the property, when the Lintons owned it in 1972, they charged the public for use of the beach and the boat launch. They also obtained a permit from the road commission to build a seawall to help control the eroding beach. Then the Keens bought the property. They also charged the public to use the boat launch. Then the dock bought the property in 2006, and they continued the practice of charging the public for use of the boat launch. How do we make sense of all this?
Yep. And Your Honor, I think there is conflicting testimony as to what the charge was for. And I would direct the court's attention to the affidavit of a gentleman named Leroy Krempick, no relation to this Leroy. This appears at appellant's appendix at page 584. And Mr. Krempick is now a township official in Ontowa County. This was, by the way, was an exhibit to our counterclaim, and has been an exhibit to several of the briefs that are part of the record. But Mr. Krempick had a different memory of this. Mr. Krempick said, and this is page 5, paragraph 5 of his affidavit, to the best of my knowledge, no persons were ever charged for launching their boats or the use of the property on the west side of Eagle Lake. Mr. Krempick's memory is, and he goes on, paragraph 6, instead, I was charged on a number of occasions, and I paid a $5 parking fee to park my truck on the east side of Eagle Lake Road. To the best of my knowledge, other fishermen also parked their cars and trucks there and were also charged the same $5 fee. And so there's no question that money was collected. The question is what it was collected for. Is it to launch the boat, or is it when you get done taking that boat off the trailer and you got to go park your car somewhere? If you went across the road and parked on what was then vacant ground, you could do that. The other point I would make, Your Honor, and I do want to correct this factual record because I think it is very flawed on behalf of Four Lakes. Four Lakes has told you that this boat launch was only erected in the 1970s by the Lintons. And specifically, they said this in their brief, and they said this in their reply brief. They state, in fact, the boat launch could not have been addressed in the Rathfin opinion because it was constructed by the Lintons in the 1970s, more than a decade after Rathfin was decided. Most respectfully, Your Honors, that statement is just not accurate. And the site that they cite to that, by the way, is to Appellant's Appendix 11 or 1311 and page 1312, which is the affidavit of their, which is the deposition testimony of their client Dale Snow, where he was asked about this, and he, in a hearsay answer to his own attorney's question, said, and this is now again quoting from appendix at page 1311, yeah, based on conversations I had with him being his deceased father-in-law, Mr. Linton, Mr. Snow says, based on conversations I had with him, unfortunately, he passed away a few years ago, but he put in the boat ramp. And then he goes on the next page, I'm going to say that he did this in mid-1970s, so 74, 76 range. That, Your Honors, is completely contradicted by the Rathfin opinion. If you look, and now I'm going to read to you from the Rathfin opinion, and again, this is starts on page 75, but on page 2 of that opinion, and this is, so it's an appellant's appendix, say that fast, page 76. At the bottom of that page, Judge Mosier he's talking about witnesses that appeared on behalf of the property owner, Mr. Rathfin. At the bottom of the page, he says, this plaintiff's witness, he recalled the county putting in logs and stones on the west side, and he testified to seeing boats launched and people using the beach for swimming and other like purposes. Other witnesses for the plaintiff testified to the use of the shoreline for travel purposes and fly fishing. That's where the language comes in. Judge Mosier took testimony from witnesses, contemporaneous witnesses, who prior to 1956 had observed these types of activities, including the launching of boats. So the statement, most respectfully in the brief, that this boat launch was not there until 1972 is completely contradicted by Judge Mosier's opinion. Let me turn, if I may, in our view, notwithstanding the fact that the word riparian doesn't appear in Rathfun, if you take this in its entirety and you look at the Wendt opinion and you look at the Rathfun opinion, I think Judge Mosier clearly gave the public those rights, and the public has enjoyed those rights and has launched boats from this activity for 70 years. And we know that because when Mr. Snow and Four Lakes claimed that the permit superseded Judge Mosier's opinion and they put the boulders in, I will tell you that the road commission's phones lit up on Monday morning like you would not believe, of people that had been using that for a boat launch for decades and were suddenly blocked by Mr. Snow. The other question I would ask you to think about, and this is more of a practical one than a legal one, is how can little Mary Smith continue to shore fish if there are boat slips in front of this and no trespassing signs? How can a person swim if Four Lakes controls the bottomlands? How can you launch a boat into the water if you can't stand on the bottomlands or if there are boulders in front of it blocking it? The answer is you can't do any of those activities. And so to the extent you would have to read, Your Honor, in Judge Mosier's opinion, you would have to read that language as pure surplusage and say that it means absolutely nothing. And I don't think that's a fair reading. I think there's a contract law and other law that says you have to give meaning to all of those words. And I think most respectfully, the judge put that in two opinions. In the Wendt one, he specifically talked about riparian rights, and these would be the riparian rights. And I don't think it is taking anything of a large leap. It's not taking any leap to say that the Rathfun case also granted the riparian rights. Turning quickly to the Dock case. And Your Honor, you mentioned Mr. Doyle said, well, the road commission said, and Your Honor, you said, wait a minute, Mr. Doyle, it wasn't the road commission. Let's look at the transcript. And I think we should look at the transcript. And this is, again, appellant's appendix. This is page 128 of their appendix, and it is page 36 of the transcript. This is a case before Judge Giguere. Judge Giguere, as you probably well know, is a Kalamazoo County Circuit Judge. He was sitting by designation because the Cass County judge had a property on Eagle Lake and recused himself. So Judge Giguere, as the judge hearing this case, described what the lawyers had argued, what the case was about. Four Lakes says it's not about riparian. Most respectfully, Judge Giguere disagrees. He says, and this is top of page 36, again, it's page 128 of the appendix. The defendant claims that the 1956 decree cuts off any claim of riparian rights at that location by defendant, parentheses sick, it should be plaintiff. And then at the bottom of that page, same page 36, also plaintiff alleges that the opinion in Rathfun did not create or convey to defendant any riparian rights to Eagle Lake. Plaintiff argues that while defendant holds an easement over the property, the opinion in Rathfun does not take away the riparian rights of the plaintiff. That's the exact argument Mr. Doyle just made to you 20 minutes ago. But Judge Giguere said, looking back at Rathfun and how it was decided, again, now this is on the next page, page 129. I believe that this was litigated in 1956, and the same claim was litigated then and resolved by Judge Mosier. I agree with the defendant, the Road Commission, that the doctrine of res judicata bars plaintiff's claim, and the motion for summary disposition on this basis is granted. This was decided in Dock. He did refer to, and he's correct, that they allege that the opinion in Rathfun did not create the riparian rights. That was litigated in the Dock case. And most respectfully, what Mr. Doyle is doing really is he wants to appeal the Rathfun decision. And he's 70 years, 6 months, and 92 days too late. That's what the real gist of this is. Now, Your Honor, to address the Wendt case, and I think you touched on a couple of the key points in this. The Wendt case, they say don't look at it. It's a completely different property. Well, as we've said, it's connected. We've talked about that. And I think at a minimum, the Wendt case can be looked at to see what was Judge Mosier's intention when he wrote the Rathfun opinion. He talks about, and this is from the Wendt memo at page 4, and I'm going to get you a cite. This is appellant's appendix at page 569. The Wendt memorandum states, plaintiffs have claimed full riparian rights to the lands adjacent to Eagle Lake and say that that strip is not part of the highway, and plaintiffs claim the right to control it and to keep the public from that strip. So there's a discussion in Wendt certainly about riparian rights. And we know that the Supreme Court then wrote an opinion, and at page 253 of that opinion, the Supreme Court says, discussing Wendt, on the basis of the proofs, it was determined that a strip of land between the highway and the water's edge had been used for various public purposes, including the launching of boats, swimming, fishing, and the parking of automobiles, and that such a use had been a constant one. The claim of plaintiffs Wendt that they had riparian rights to the land adjacent to Eagle Lake and that the strip in question was not part of the public way was rejected. This is the Supreme Court saying that the Wendt trial court rejected the claim of riparian rights. Mr. Doyle comes before you and says, that didn't happen. Well, most respectfully, I'll weigh in and I'll side with the Supreme Court on this one. They did decide that. Now, the language in the Wendt case, the court, Four Lakes cannot realistically claim that that's not a riparian rights case. And the issue then becomes, is Rathfun also a riparian rights case? And I think based on all of the things we've discussed, I think the answer is that it is. And Mr. Doyle says, well, I can't find any other case where this is. I'll give you two. One is called Rathfun and one is called Wendt. And whether we agree or disagree with what Judge Mosier did, it's what he did. And that opinion was gone up to the Supreme Court, and I'm not sure that you can turn around and take that away, and certainly not 72 years later. And Judge, to your question on the Wendt 2 case and the fence issue, and why is the fence not different than this? The fence is exactly the same. But what Mr. Wendt did, being a little bit cantankerous, I believe, was he said, fine, court, to the Supreme Court, you said that, or excuse me, to the trial court, you said that I only have certain rights here and that the public has these rights. And if you read the opinion, what they did, and this is my finger moving, he put a fence that weaved in and out for 1,800 feet. 1,800 feet's more than a quarter of a mile. Quarter of a mile is 1,300. This is 1,800 feet. And he had the fence going into the water and then back out of the water and then back into the water and back out of the water. So he's got a snake-like pattern of this fence that prevented the public from using for access to the water and from using the water and from launching boats and from shore fishing and from all of those activities that he put this barbed wire fence up. Supreme Court says, very funny, but we're not going to go there. You are obstructing with the public's riparian rights. Mr. Snow comes along 70 years later and says, I'm going to get a permit from Eagle. I'm going to claim that the permit from Eagle supersedes and overrules the Wrath Fund judge's opinion 70 years ago, and I'm going to put boulders and stones in the waterway and block the public's access. Judge, it's just the exact same thing you said. It's the same as the fence.
I'd be remiss if I didn't tell you, counsel, we've got 1 minute left.
Your Honor, we have a number of arguments I've raised on the key ones. First of all, thank you for the warning. The arguments in terms of the rebuttal to Four Lakes arguments I've raised, the key ones here, I will stand on my brief as to the others, and the other counts are somewhat dependent on your decision on this issue. And we believe those should be affirmed as to the trespass and those counts in our counter, or the dismissal of those counts. And most respectfully, the judge got it right on the attorney's fees. This claim should never have been brought. They were told it shouldn't be brought. They did it anyway. They did it because they're a real estate developer and they wanted to make money. And Judge Herman correctly said, that's enough, stop. And that's why he awarded the attorney's fees. He was correct in doing so. Thank you very much.
Thank you very much. 2 minutes.
Thank you, Your Honor. I'm on the clock and I appreciate that. This case is nothing like a fence. What we're seeking to do here is nothing like a fence. We're not seeking to keep young Mary Smith, as Mr. Asher said, from fishing. The public has all of those access rights. We can't do anything about that. We're not seeking to change that. We're seeking to exercise our riparian rights, to anchor a boat. Right now, the Road Commission says Rathfon took and granted all of our riparian rights to the public, so we can't put a private dock up and we can't anchor our boats. That's what we're looking to do here. We're not trying to keep anyone from fishing, from launching boats that they can launch from the roadway easement. Mr. Asher said people can't touch the bottomlands. That's not true. We all know how lakes work in this state. If you have lakefront property, people are boating back in front of your house all day. They're swimming in front of your property all day. If there's an easement, they're going in and swimming and they're coming out. That's how it works. That's how we want it to work here. We just want to be able to exercise our riparian rights and have a dock. That's what we want here. We're not looking to restrict public access. Number two, Mr. Asher said it clear as day. He says in Rathfon, the public was granted riparian rights. There's not a case under Michigan jurisprudence where that's ever happened. You'd have to make new law for that. Judge Mosier didn't say that. He didn't say, I hereby grant the public riparian rights. He didn't do that. And there is no basis in that opinion for that holding. He established there's a roadway easement. And we know that roadway easements by operation of law do not grant riparian rights. On the boat launch, I want to correct the record. It's not based on hearsay. The boat launch was built in the 70s, and we know that from Mr. Snow's wife, who testified, this is at our appendix at page 287, that her father installed the boat launch after he purchased the property in the 70s. So Mr. Asher is wrong about that. What the court in Rathfon was referring to is the public would use the easement to launch boats. And of course you can launch boats without having riparian rights. When I go through someone else's land to launch a boat, if there's an easement, it doesn't mean I have riparian rights. It just means I have the right to access the lake if there's a way to do it. So you don't need riparian rights to launch a boat, to fish, to swim. None of what Mr. Asher said there is true at all. And because he doesn't have the law or the facts, he slings mud. He says this is a greedy developer. This has been property that's been in the family for a long time. And we are looking to return to the status quo where the property can exercise its riparian rights in harmony with the public who can exercise their easement access. That's what we're looking to do here.
Thank you.
Thank you very much.
All right, thank you very much for the terrific oral argument as well as the very substantive briefing materials. We appreciate it. We will retire this for consideration. The matter is submitted.
Yeah, both of you were very good. Thank you.
We are going
Thank you, Your
to
Honors. Thank you for your time. Judge O'Brien, nice to see you again. We tried a case 20 years ago for a month in Oakland County on the Northland Michael York asbestos case. So it's good to see you again. Thank you.
Nice to see you too. Take care.
All right, we're going to take a brief recess. Thanks. You can have a seat. We have two more matters. Calling the first, and these are consolidated, item number 7 on the docket. And that is docket number 368236 and 368343. Kirk John Bush versus Lori Lynn Bush. And I understand that Attorney Schmidt, hello, good to see you. I would also acknowledge for the record, while he is not endorsed for argument, Mr. Day is present, and I've allowed him to sit at council table if there are any questions for him. But Ms. Schmidt, this is your show, so please take it away.
Thank you, Your Honor. Good afternoon, Your Honors. My name is Lisa Schmidt. I'm appearing on behalf of Appellant Kirk Bush. As Your Honor noted, I was expecting to be the only one talking today since opposing counsel was not endorsed for oral argument. I'm also very aware that it is 12:30 there and we are still on the 7 o'clock docket. And so I am going to keep things very brief. I'm going to give you a 1-paragraph summary of the issues in the case, and then I am going to make myself available for questions. I think this issue was very thoroughly briefed in the extensive cross briefing that occurred in this case. And it all really does boil down to one decision by the trial court. So I think that we should be able to get you moved on relatively quickly. Spousal support awards are supposed to be based on 2 things: income and need. The trial court's decision here, refusing to terminate spousal support, was based only on income. Husband's ability to pay, which is substantial, and the disparity in the income between the parties. However, the trial court found specifically that the wife was now self-sufficient and generating a good income for herself and her husband. That should have meant that support was terminated because there was no longer need. Because the wife had concealed her income for 5 years, retroactive modification was appropriate under MCL 552.603B. And according to the terms of the judgment itself, attorney fees and costs were required based on that failure to disclose. They are also appropriate
I don't know if that is quite that cut and dry on either of those 2 issues. So I'll be curious to hear you elaborate, but it seemed to me that Judge Engel found that wife merely forgot to make the 10% disclosure. And as I read these materials as well, as to your second point, that language is really kind of ambiguous and I think improper grammar. I read that provision over and over again. And, I am not the English major, but it almost appeared that the party who attempted to raise the issue would be liable. And now let me look at my materials to see. I just don't think it's cut and dry. And I don't think it's cut and dry for that reason, as well as there was reference made again, ambiguously, it isn't an automatic that you will get attorney fees and costs. It was just very oddly worded. So can you, maybe you were intending to go there. Can you help me with each of those points? Because didn't Judge Engel find that this was a mistake rather than deliberate hiding of resources?
So I agree that Judge Engel made one comment that it seemed to be unintentional. And that certainly was the wife's position. However, that is belied by the record, because after she was found out, she proceeded to obstruct discovery to the point that a motion to compel had to be filed on March 28th, 2023, in order for her to simply disclose the assets that the company had earned. So if this was an accident, she should not have been continuing to fight over the disclosure of that income. I think that her actions during the proceedings demonstrate that it was willful and intentional.
Okay, and I appreciate that explanation. And now I have in front of me the language. Failure to provide the 10% increase to the other party will expose that party to the payment of attorney fees. That hardly seems mandated. But again, grammatically speaking, I read this several times. Failure to provide, and maybe it's because it could have been written better, but failure to provide this information to the other party will expose that party. Well, that refers to the last proper noun.
I think that I understand what your honor is saying as far as trying to parse the grammar of that sentence, but I think that we should read that sentence as that party and the other party are indicating two separate parties, right? And so otherwise, as you said, it would create this unintended interpretation where the party that was supposed to receive the information was the one on the hook for attorney fees. And that's clearly not what was intended when you take the section as a whole. This was intended to be a sanction for non-compliance.
Okay. And as I recall in my review of this matter, because the other thing I looked at when I saw what I considered to be an ambiguity was, as you know, generally the party who drafts the language is held responsible for the language and the other party gets the benefit of the doubt. But it seemed as though this language came directly from Judge Engel's written opinion, from which the parties based the judgment of divorce. So
yes, I don't think we can interpret the language in one person or the other's favor here, because I think it is directly from the judge's opinion.
Yes, I thank you. I appreciate that. But let's focus on the word expose. That does not seem mandatory to me.
I can see that argument. However, as I said, attorney fees are also appropriate under MCR 3.206 D2B because of the misconduct by violating the court order. And so even if we have two bases for a discretionary award, I think that given the 5 years of non-disclosure and the fact that her income had increased 125% beyond the imputed income in that time, I mean, this is some significant misconduct. She knew what she was doing. She was taking advantage of the fact that she was getting thousands of dollars every month so that she didn't have to rely on her husband for care or for like the new marital home expenses. She could just cut him out, make him pay a little bit here and there, and then use her money for what she felt was good feelings, right? She has this other home that she's not even bothering to get rent from because she feels bad for her friend. Great. I feel bad for her friend too, but that doesn't change the fact that she's hiding her income to maintain that level of support. And I think that means that an award is appropriate under the court rule. And I think it definitely should have exposed her to the attorney fees sanction that was listed in the judgment. And I think that the trial court here clearly kind of went back and found a reason why it had awarded the $1,000 in attorney fees. That number is not in any way related to the reasonable costs and attorney fees that were related to discovering the information, as the language suggests. It's more like, well, this is what was left, so that's what we're going to count as the sanction. And I think that in itself is reversible error because it does not follow the process that has been laid out for how to determine what a reasonable attorney fee is under Purdue.
I think Judge Engel was hoping he could cut off any protracted litigation.
I agree with you because he said it multiple times. Unfortunately, Judge doesn't get to abdicate his obligation to go through the appropriate processes just because he's tired of dealing with the case.
Thank you. Thank you for engaging me. Are there other things other than relying on your brief that you want to indicate for the record here?
We've covered a lot of it. I would just point out more clearly, with regard to our argument that the spousal support award as continued essentially becomes a windfall for a non-party. Here, the husband in the case is sharing the 50% interest in this business that has an annual income of $200,000. But he's only paying $1,000 a month for his expenses. And that includes everything from utilities to groceries. He's not paying rent. So where is that money coming from? It's coming from his wife's ex-husband. That's not the purpose of spousal support. It is not supposed to benefit third parties except for possibly the dependents of the parties, meaning their children. That's not what was happening here. That spousal support was being used for an improper purpose, and therefore it should have been terminated.
Thank you. Other questions?
No questions. Thank you.
All right. Thank you very much, Ms. Schmidt. And counsel
I will
officially.
just reserve for rebuttal in case there's anything that comes up from the questions.
I'm guessing we have none, but I'll allow counsel to put his appearance on the record, and then I will ask my colleagues.
I'm Devin Day here on behalf of the athlete.
Thank you. Any questions for Mr. Day?
No questions.
No, thank you.
No questions. Thank you. You are both free to go. And thanks for your time as well as your patience getting to this point of the docket. Have a good day. This matter is submitted. Leaving, last but not least, Mr. Feller. Good morning, good afternoon. Though it isn't. Yeah, it is still morning in Chicago.
Still morning in Chicago.
There we go.
Right.
Okay.
Just made it.
This is item number 8 on the docket, our last matter, 372-908, People versus Mark Anthony Abatoy. And Mr. Feller, good to see you again. I believe you argued. Did you argue the?
I did. This is my third time.
Yeah. Okay. You've been with it the whole while.
The whole way since
Okay.
2019.
All right. Take it away.
Thank you. Leonid Feller on behalf of Mark Abatoy. I'm happy to be here, but I would say unfortunately here for the third time because I think the circuit court both continues to make the same mistakes that have brought us here twice before and has also managed to make new mistakes. So in terms of the same mistakes, first, the circuit court continues to be unable to properly apply youth as a mitigating factor in at least 2 regards. First, the circuit court, in attempting to apply youth as a mitigating factor now for the third time, said, quote, "This court understands that the defendant was 17 years, 6 months, and 7 days old when this violent murder was committed. I would consider his youth because that's why we had the Miller hearing." Both Boykin and Abatoy too explained that that the fact that we're here is not a mitigating consideration in mitigation.
Well, and when you read that sentence in conjunction with his, I think it was the second sentencing or maybe the first sentencing where the judge uses the same language to criticize the fact that if the kid was, if he wasn't more than a couple of days away from being 18,
Right.
he wouldn't have to be there.
Right. Exactly. Which isn't even the law anymore anyway. But second, the other problem is even to the extent that the circuit court gave lip service to youth as a mitigating factor, what Boykin and Abatoy too teaches is youth is not, we don't balance youth against the need for the deterrence or the need for punishment. What Boykin and Abatoy too very clearly say is you have to apply youth to each of the snow factors. And so this is the language from Abatoy too, quote, even the circumstances of the offense, albeit heinous in nature, also indicate the hallmarks of youth. Miller contemplates scenarios not unlike Abatoy's offenses by children who were physically abused and neglected, unable to extricate themselves from a violent upbringing, and offenses by children who were, at the time of the offense, under the influence of drugs. And so you don't see any of that sort of analysis in the circuit court's now third sentencing order.
It almost seemed to me that there was acknowledgement and perhaps too much faith and credit put into the one note that came from your client's mother, I think, at one point, if I'm recalling correctly, where we were a great family or, Christian values or something like that.
Right. Well,
without looking beyond the curtain.
That's right. Well, so I was going to say one of the new errors that was made is that the circuit court actually said in ruling that Mr. Abatoy had and this is a direct quote, a nurturing and balanced upbringing. This is someone who was abused literally every day, according to his mother, was hit with a paddle, was beaten by his brothers to the point that he had to flee the house, ran away to California at one point, was raped, was untreated, had untreated mental illness. And in fact, untreated mental illness in the sense that they went to the hospital, he was prescribed lithium, and mom and dad said, no, we're not going to get you the pills. So I don't know how that that can be considered a nurturing and balanced upbringing. Repeat error one, failure to apply youth as a mitigating factor. Repeat error two, almost, I would say, singular focus on the circumstances of the offense. I know this is your second Miller hearing today, or Miller-related case today, and I will echo what the counsel there said. No one defends any of the conduct that took place, but they're all heinous. I mean that unfortunately is the nature of it. And if that was sufficient either for a life without parole sentence or a maximum term of year sentence, then this court's docket, I imagine, would be smaller than it is. So
we have a co-defendant whose mother was the victim.
Correct.
And the co-defendant has acknowledged that, but for him asking for the assistance, that he would never have committed this. And yet that co-defendant, who also was an active participant here, is now paroled.
Well, and so that's why I keep coming back here for year 6 now, right? So we have, and look, I suppose reasonable minds can disagree. But by my lights, the co-defendant by any measure is at least as culpable, if not more culpable. This was his plan to knock out his mom and steal her car. He was older. He didn't suffer from mental illness. Everyone agrees that Mr. Abatoy, my client, was susceptible to peer pressure from this individual. In terms of who hit the fatal blows, who knows? There's, I wouldn't even say there's disputed facts on it. There's
Mr. Abatoy turned himself in and confessed.
Mr. Abatoy turned himself in and confessed the next day. There's actually, I'm not sure if it's in this brief, but there's prison recordings of Mr. De Palma.
If it's not in the record, please don't.
Okay, I apologize. It's definitely in the circuit court, but there's certainly issues with acceptance of responsibility with Mr. De Palma. So I don't know how proportionality and fairness allow for the result we have here which is really as a function of having two different circuit court judges. Mr. Abatoy has been in prison for 5 additional years. So, and the one other error I just want to highlight is in analyzing the Snow factors, the circuit court in looking at protection of society said that Mr. Abatoy's mental health issues continue, meaning he treated mental health as an aggravating factor for a longer sentence. Bennett tells us you just can't do that. It's the exact opposite. So the question now is one of remedy.
I wish you would have put that as a head note. No, I do. I wish you would have put that just for future reference.
Sure.
I would have loved to have had that as a head note in the briefing.
Okay. I will say hopefully not next time, but take it for the next case.
I mean,
Yes,
the
understood.
global,
Understood.
the global next time. I didn't mean in this case.
Understood. And so the question is one of remedy. I had a lengthy discussion last time I was here about whether this case goes back to Judge Lasada. Sorry, I'm mispronouncing it. Obviously it was sent back last time. I hope that will not happen again. But to your point, Judge Rick, it's been 5 years at this point that Mr. Abatoy has been imprisoned. There's a case we cite called Kellogg 467, Michigan 856 that allows this court to remand with directions to impose a specific sentence.
Can you give me that site, please?
Sure. Kellogg 467, Mich 856.
Thank you.
There is simply nothing, I don't think, on this record that warrants anything other than a minimum term of years sentence. All of the rehabilitation, everything that Mr. Abatoy has done, the GED, the working with prisoners, the
But
acceptance.
he's doing some
Really difficult work.
really challenging work.
He is. He is, in terms of his mental health, he actually was taken off paneling back in 21 or 22. He was doing that well. At his Miller hearing, we had testimony in his favor, both from a current MDOC employee, his treating psychologist, and a former employee, Mr. Stapleton, who talked about his record of rehabilitation and how few violations he had. So he has been in a level 1 facility now for 3 years. Before that, he was in a level 2 facility for, I think, 10 years. So I would certainly, to the extent this court is willing, I would urge you to consider perhaps ending this after the amount of time and simply imposing a sentence rather than sending it back to a new judge.
No questions. Thank you.
Thank you.
Good. Thank you.
Thank you
Safe
very-
travels home.
I appreciate it. Thank you.
Thank you. We will submit this matter, and that concludes our docket here today, the November 2025 session, panel 8. We are adjourned. Thank you.